The right to an abortion is already recognized in Montana and has been since 1999. But on this year's fall ballot, voters will be asked whether to spell out those rights explicitly in the state constitution. The outcome could reshape Montana's long-standing debate on abortion rights. Montana PBS's Hannah Kierce reports on Constitutional Initiative 128.
At a reproductive freedom rally in Bozeman, rallygoers carry homemade signs and cheer on speakers advocating for autonomy. The crowd features people of all ages, showing a movement that crosses generational lines.
Most importantly, this is about autonomy. My mom's generation of women was the first to have so many rights they hadn't been afforded before. When she had me, I'm sure that my mom expected my generation would have those same rights.
But there are also many Montanans with pro-life views and may oppose CI 128. For some, their political stance is rooted in their religious beliefs. Like you see here, with people gathering at the state capitol for a Christian concert led by pro-life activist Sean Foich. People sing along and take communion as part of a public worship. Foich's message often blurs the lines between religious freedoms and political activism.
There's a lot of issues in this state. It's not as free as many of you think it is, okay? So we got all kind of issues. We got all kind of problems. But yet we stand here today lifting up communion in front of this building, declaring the blood of Jesus is enough.
The state legislature's efforts to impose new restrictions on abortion have faced major setbacks in the courts, who have struck down most of these bills, keeping Montana's abortion rights intact for now.
Last session, we passed common sense pro-life bills, some of which are now tied up in the courts. But our commitment to doing what's right for unborn babies will never waver.
But for advocacy groups like Forward Montana, this commitment by the legislature and the increasing dependence on the courts to continue Montana's abortion rights signals the need for stronger protections.
As we have seen from the past couple legislative sessions to language from elected leaders in our state who are calling on the courts to overturn Armstrong, there is no better time than now to protect access to abortion in our state.
Since 1999, the Montana Supreme Court's Armstrong ruling has extended protections for abortion under the state's privacy law. But Montana lawmakers saw an opportunity for the courts to reinterpret this law when the U.S. Supreme Court ended nearly 50 years of federal protections on abortion rights.
The brakes are kind of off on the legislative side. In Montana right now as well. One thing that we're seeing is a whole lot of abortion litigation in Montana, which there has been in the past, but not nearly to the degree that there is right now. Constitutional Initiative 128 would prevent, really limit the necessity of litigation going forward. It is the right of privacy is really strong and it reads really broadly. CI 128 is much more focused on abortion and says exactly what does and does not pass constitutional muster.
CI 128 would allow abortions before fetal viability and abortions at any point in pregnancy if a treating healthcare professional determines it is medically indicated to protect the pregnant patient's life or health. And it prevents the government from penalizing anyone who assists someone in exercising their right. Most of CI 128's legal criticism centers on claims of vagueness. Senator Keith Regier recently passed a bill targeting the foundation of Montana's abortion rights, aiming to explicitly remove abortion from the state's privacy law. And Regier is among Montana lawmakers saying CI 128 is too vague.
There were those that testified that the language is vague, and it really is. Viability, medically indicated, good faith judgment, those are very subjective terms and really need to be defined better in order to go on.
The predominant pro-life organization Susan B. Anthony, Pro-Life America, is also focusing its criticism on the ballot measure's language.
It uses the word viability, but what it does in practice is allow second and third trimester abortions, and it enshrines it in the Constitution. This isn't just a law we're talking about. This is your Constitution.
Viability is a notoriously vague term. It's generally considered to be around 24 weeks of pregnancy, but medical experts say that this can vary depending on medical technology and patient conditions. This is why courts have historically been reluctant to set a specific standard for viability, as it naturally opens the door to legal challenges.
One criticism of Roe v. Wade is that the court was acting like doctors when they looked at viability, and they looked at what you can do in the first trimester and the second trimester, and that it's a medical, not a constitutional kind of concept.
CI 128 would make it harder for the state to have a say in defining medical concepts of abortion care, which its critics argue are too vague. But legal experts suggest many of these claims of vagueness may be overstated, like the concern that the initiative would allow unqualified professionals to provide abortion services.
What it does through a gaping health exception that is undefined is allow for essentially abortions at any point in pregnancy, because it allows the abortionist, does not even say a doctor, it's an abortionist or anybody who does the abortion, to decide when an abortion is necessary based on health.
CI 128 says a treating healthcare professional can determine if an abortion is medically necessary. And this means only someone who has the proper credentials, which permits them to make medical decisions within their expertise. This includes healthcare professionals other than doctors, like certified midwives and advanced practice registered nurses. Last year, the Montana Supreme Court reaffirmed that there is no evidence of this posing a medically acknowledged bona fide health risk to Montana women. Another criticism of CI 128 that echoes concerns raised in recent legislation is that it would permit taxpayer money to pay for abortion care.
This amendment is going to make you pay for those abortions, and not just life of the mother kinds of abortions, but elective abortions all throughout pregnancy.
So how is abortion care and taxpayer money linked? In Montana, the answer is Medicaid, which is funded by both federal taxes and state taxes. But the rules on how these funds can be used differ. Federal regulations limit the use of federal tax dollars to cases of incest, rape, or a threat to the life of the mother. But Montana's Medicaid regulations say that state tax dollars must also cover medically necessary abortions. The state alleges that taxpayer money is paying for elected abortions because of this additional condition in Montana's Medicaid. The legislature passed a law that would give the state the power to define what qualifies as medically necessary for Medicaid abortions. However, a district court is currently blocking this law. But if passed, CI 128 would ensure that treating healthcare professionals would make this decision. And supporters of the initiative are saying that these claims of vagueness are a political tactic designed to mislead the public.
Extremists in our state have shown time and time again that they are willing to do anything and everything to restrict access to abortion in our state or eliminate it entirely.
In many ways, CI 128 looks a lot like Montana's current abortion rights. The important difference is CI 128's functional power.
I think, though, in terms of sort of precedential power and kind of sticking power, having the voters weigh in directly on something gives it stronger effect than having a judge weigh in on it. And part of that is because it is the voters telling the judges not to second guess something. So courts overrule their precedent. There are different ideas about when they should do that, how often they should do that, but they can't override what is directly in the Constitution.
CI 128 would take much of the abortion debate out of Montana's courts, and that appears to be an objective for both supporters and opposers of this initiative.
We've seen the state legislative cycle after cycle, or session after session, do what they can to restrict access. And so the time is now to make sure that it is enshrined in our state's constitution.
Montana's current Republican-controlled legislature, Attorney General's office, and Governor's office have shown a strong interest in taking over the regulatory role on abortion. It's passed a record number of abortion laws that contradict the protections outlined in CI 128.
We're really supportive of Governor Gianforte and the bills that he signed 2 legislative sessions ago that were helping with women's health and safety protections, amongst other things. Unfortunately, the Supreme Court has struck some of those common sense things down. And so I think it's us being a good partner to the governor.
The state's lawmakers and judges have primarily controlled decisions on abortion rights, but this November, Montanans will directly weigh in with their vote on CI 128.
I think there's always an avenue for constitutional interpretation to change. CI 128, if it were passed, would be a lot harder to change the interpretation of, because it's just much more granular.
For Impact, I'm Hannah Kearse.
Montana is one of 10 states voting on abortion rights in this year's election. After the U.S. Supreme Court overturned Roe v. Wade, a national movement has grown to define abortion rights at the state level.